Manera, it's me, AV, and welcome back to my YouTube channel. I'm so happy that you guys are here. I'm really looking forward to continuing our case brief series, okay? And today we continue with Planned Parenthood v. Casey. If you were here last week, or even if you are new, welcome. Check out my case brief series. My name is AV. I am a third-year law student. I have a bunch of stuff going on. I go to law school part-time. I'm about to wrap up, and I have one class left. If you want to check out my case brief series, what I do is I take cases and I break them down into digestible pieces for you guys to digest before you go into different platforms. And it's also designed so that you guys are informed and you know what these cases stand for and what they mean. And a lot of them are going to be in popular media today. So it kind of helps you get some background before you go off into the world and talk about these cases, right? Really looking forward to continuing on this case series with today's case. All right, let's go to work. Let's get this done, right? Let's start with today's case. Today's case is Planned Parenthood v. Casey. This case was decided in 1992, and it was delivered by Justices O'Connor, Kennedy, and Souter. As mentioned, I always like to let you guys know the first name that you see in a case, Planned Parenthood, which is a business entity, versus Casey, who is the governor in Pennsylvania. We'll get into that in a second, but sometimes if there are government officials, if you do need to bring a case forward, you sue that government official. It's not them personally, but it's just they're acting on behalf of the state. Of course, you guys know that we do this in a traditional law school case brief format. So let's start with the issue. What is the issue in this particular case? The issue in this particular case was whether the Pennsylvania restriction on abortion that requires informed consent and a waiting period. Was it constitutional? Was it? I don't know. We'll find out. Let's talk about the holding. Okay, we talked about the holding before. If you have not seen any of my case brief videos before, we do this very structured in the form of a law school case brief. So please go back and check out Roe v. Wade last week, because this case is connected to that in this series, okay? So let's talk about the holding. The result is no. The holding of Roe v. Wade was reaffirmed in this case, and you guys will see why in a second. Stare decisis operates as a governing principle in nearly all court decisions, okay? All of the Supreme Court's decisions, to be exact. But let's talk about stare decisis. I want to make sure that you guys understand what this concept is. It's actually a term that is Latin, and in Latin it means to stand by things decided, okay? It's the doctrine of precedent, and really what that means is a court must follow earlier judicial decisions that it's made already, right? So if the same points come up again in litigation, it's kind of like, hey, we've already decided on this already. Why do we need to look at it again? Sometimes they will look at it, and you'll see this in this Supreme Court decision. They will look at it if there are some contours of the law that just need to be tweaked or refined and things like that. This case is super controversial, but we'll continue to dive into it, okay? But lastly, I just want to leave you guys with, in this section, precedent holdings generally should only be overturned if there are changing circumstances. So like I said about the contours, right? That make the previous rules unworkable. That's a big thing in this case. So let's get into that. Before we do, you guys know we have to talk about procedural history. And if you're new here, then you need to know that procedural history is how the case moves through the court, okay? So this case originated in Pennsylvania. It was in a district court in favor of Planned Parenthood initially, but the Court of Appeals upheld a majority of the Pennsylvania provisions in this statute, except just one thing here, the requirement of spousal notification, right? Then the Supreme Court took on the case for review. Let's talk about the facts. It's tea time. This is where the tea lives in the cases, okay? So I'm going to try to zip through this one because it's not lengthy, but at least you guys have the background on how this case ended up here. Planned Parenthood was an organization. They sued the governor of Pennsylvania at the time for enacting specific legislation, okay? They did this in a federal district court for the purpose of challenging 5 restrictions on abortion under Pennsylvania law. Let's start with number 1. The first restriction was a woman must give her informed consent to the abortion. Number 2, she must receive certain information before the procedure is performed. Number 3, for a minor, at least one parent must give consent, right? There are some restrictions where if the parent's unavailable, depending on the situation, it might be harder to get that consent. So they do have some, they have some exceptions, but just wanted to stop there and let you guys know that. Number 4, a married woman must sign a statement indicated that she's notified her husband. This is a big one. We'll talk about that towards the end too. And lastly, the facilities that perform these abortions must comply with specific reporting requirements. So, how the court ruled in this particular situation, but what we are going to talk about right now is the reasoning and why they decided to do what they did, okay? And there's a couple of things that I wanted to chat with you guys about. When I did dust off my old constitutional law book, I had to really look at how the court ruled in this. And let me give you guys a disclaimer. Constitutional law, whenever there are constitutional law cases, these cases are very long, okay? You guys saw my constitutional law book last week in the Roe case. These Supreme Court decisions are long because you have 8 to 9 justices writing an opinion, okay? And that's 9 people giving their thoughts. Sometimes they do it in groups, sometimes they do it in smaller groups, sometimes you'll have a dissent and it's just one person that's just like, I want this on the record, I disagree, and here's why, blah, 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 right? But let's talk about the reasoning, because this week I'm actually going to give you guys some dissents, and we'll talk about the dissents starting now. But as far as the reasoning, went through the con law book and really decided to look at what the majority opinion was, meaning that the group of justices that won in this case. And a couple things came up. The first was the right to privacy under the 14th Amendment. I'm not going to cover this because you can go back to my video on Roe and you can learn more about the right to privacy and why they decided the way that they did in Roe v. Wade. The next thing was the liberty to choose. Okay, they mentioned that there was a profound moral and spiritual implication of terminating a pregnancy. I think we can all understand that, right? But the court acknowledged that. That's why this issue is so controversial. Next thing is stare decisis. We talked about stare decisis. When you have a case that comes up again for review, it's not the same case, but it's based off of similar facts and it's based off of a similar ruling. What are the contours that we need to change under this review, right? They also brought up Justice Cardozo. This is like judicial ammunition. Justice Cardozo was a very, very popular justice back in the early 1920s. And they mention a writing that he put together called The Nature of Judicial Process 149. And it's a 1921 writing. But it was really complemented with the concept of stare decisis. And hey, when we decide something, do we review it again? Let's keep going, because I think the biggest thing with this, on this particular review, the only thing that they changed in 1992, reviewing Roe and the decision before them, was the getting rid of the 3-trimester framework. If you saw last week's video, then you know Roe v. Wade established a 3-trimester framework. What that means is, in your first trimester, if you're pregnant in your first trimester, you can essentially have an abortion without the government impeding on your rights. Your second trimester becomes a little bit more difficult. And third, obviously, you have a well-developed fetus. And last week we talked about the concept of quickening from English common law, those type of things. So I'm not going to get into it again. But what does come out of this is the undue burden analysis. Okay, that's what this case stands for. And there's really 5 things that they talked about. The first thing was enacting the undue burden analysis, and that means that we don't want to make it impossible for women to have abortions, right? We don't want it to be an undue burden on them, okay? The second thing is the court in this particular case rejected the rigid trimester framework outlined in Roe because of the interest in potential life. The state may take measures to make sure that the women's decision is informed. So they did give the states that. They were just like, hey, if you want to be able to enact laws and make sure that you have a discussion with someone who's like, okay, you want to have an abortion, here's what you need to know. They provide them with information to make sure that their decision is informed. Maybe that procedure isn't done the same day. You give the person or the patient time for them to really consider all the options that they have. They did give the states that those measures altogether cannot be an undue burden. Okay. What's the third thing? States may enact legislation to further the health or safety of a woman seeking an abortion. So you can do that, no problem. What's the fourth thing? The undue burden does not disturb the central holding in Roe. The state may not impede on the ultimate decision of abortion before viability. Again, viability connects to trimester 1. Okay. Between trimester 1 and trimester 2 is where you have viability. So I just wanted to mention that. And then lastly, the state may continue to impede only if and when the decision is necessary to protect the life of the mother. So this is a new thing we're doing this week. Let's talk about the dissent, right? A partner has mentioned kind of what you can learn from a dissent, and I think some of you know what I'm talking about here. So what I actually did is read through not only the majority opinion, which just gave us a rule of law, but I read through the dissents as well, because this is going to be overturned, right? So I wanted to see what people were thinking before, you know, we kind of see this happen in the future, right? Because this case is in 1992. We're in 1992 right now. 20 years later in 2022, it's a little bit different, right? So let's go through the first dissent. The first dissent came from Justice Blackmun. And you guys heard me tell you last week, Justice Blackmun wrote the decision in 1973. When he put his dissent together, this man was 83 years old, right? So it's very interesting. He dissented in part and concurred in part. Dissent meaning he disagreed, and concurred meaning he agreed in part as well. He didn't disagree with the way that Roe was ruled, especially if you're the person that wrote it, right? If the standards were adjusted though, it would impact the availability of abortions for women. And that was his concern, and that's what he wanted to put on paper. Here, there is a discussion regarding the strict scrutiny test. We talked about that last week as well. And the request from the other justices to adjust it from strict scrutiny to rational basis as a standard. So that's his thing. He also mentioned, he's just like, hey, you know, if I go, I'm 83. You know, if I lose my seat, you know, you're going to have an imbalance again. And if somebody agrees with that other opinion, you know? Now, here's the other thing. You also have Chief Justice Rehnquist. At the time, you had Justice White, you had Justice Scalia, you have Justice Thomas, mainly conservative thinkers, but also originalists as well, constitutional originalists. And what that means is they really look at the words in the Constitution to mean what they mean at that time. Now it's tough because we are in a modern environment, right? People that wrote something down on a piece of paper in the 1700s are going to think differently than people in 2022, right? Anywho, I just wanted to give you guys that because they dissented in part and concurred in part. There's a need for something to be included in the Constitution itself for thinkers like this, right? Questions they may ask is it a fundamental right? Is the right to an abortion, is the right to privacy a fundamental right? These are questions that you have to grapple with in the law. The way Roe was decided provided for the right to privacy to be fundamental, making it too broad. So this group of justices, to the last point, they really wanted to adjust it from strict scrutiny to rational basis. We had talked about that in another video, but at least I just wanted to give you guys an understanding of what these justices were thinking at the time. So what's the rule of law? What is the rule of law as it stands right now today? The rule of law is a state abortion regulation places an undue burden on a woman's right to an abortion and is invalid if its purpose or effect is to place a substantial obstacle in the path of a woman seeking an abortion before the fetus attains viability. And we talked about what viability means. That wraps up Planned Parenthood v. Casey. Guys, listen, you know I keep my personal opinions out of these cases. This is just to give the general public some sense of what these cases mean and to give you some background. These are cases that are current, that are in the news, or they're being talked about in present day time. So I wanted to make sure that you guys have the information that you need. Please subscribe, please like, please comment. I welcome all of your feedback. Ring the bell so that way you know when I am producing a new video and pushing it out to you guys.